Careblazers, I have a very special guest that many of you will recognize. She's been on the channel before, but she's also one of our recurring guest experts inside of our Care Course community, the wonderful, amazing Jane Allison Austin. Welcome.
Hi, Dr. Natalie. Lovely to be with you, as always, and the Careblazers.
Yes. You know, we probably should have done this in person. I was just with you in person.
I know, but it's kind of fun over Zoom too, so
it is fun. And as a warning to everybody, these YouTube videos are usually planned well in advance with preparation. However, today, like hours ago, I sent Jane Allison a text because of a personal case I was hearing about. And I was like, we need to clear up all this confusion and misunderstanding about power of attorney. In a couple of hours, let's go record live. So thank you so much.
Yeah, you bet. As you know, I get a little nervous on these things, but it's always easier doing them with you. So anyway, yeah. So let's do it. Let's go.
And I found if I only give you a couple of hours of notice, then you only have a couple of hours to be nervous. I'm not going to give you any more notice than that. It's going to say, let's go. We're turning on the camera.
There we go.
Okay. So I want to tell you about a recent situation that happened, and I want that to be the jumping off point on, clearing up the confusion on power of attorneys. Here's the situation. I was talking to a neuropsychologist, and he was testing a person for suspected dementia, and the son brought him in. And the son told the neuropsychologist, the primary care provider said, because my dad has dementia, he can't sign power of attorney paperwork, and now I don't know what to do. And when I heard this, I'm like, this is not accurate at all. Like, this is really bad information. So let's just stop there and say, is this true that a primary care provider or any medical provider can stop somebody from signing a power of attorney?
Excuse me for a second. My assistant is here. I got your question. I'm so sorry. Chicklet, say hello. Is that okay? Okay. Now go be just quiet there. Okay. Sorry about that. Okay. So that's a fabulous question. It's really important. And I think we should look at it because I get this frequently in my DMs on Instagram and in other contexts and some from clients as well. So from the standpoint of a doctor making a diagnosis, right? The short answer to the question is a physician does not have the authority to determine legal capacity for signing documents. Now, that's the short answer. So let's get into what's really important, which are the facts and circumstances, as we lawyers like to call them, of any given situation. So as you know, Dr. Natalie, from your professional experience, and as I know from having had two parents with Alzheimer's and dementia, it's a journey, right? It's a continuum of the disease or disorder. I never like to call it those things, but we know it is this. So there's a continuum of the journey. And so, for example, my father, from the time that we first recognized symptoms looking back, right, to the time he passed away was 10 years. And so in the early years, he was confused at times, but not all the time. The last couple of years, there would have been no way that he would have been able to have capacity to understand. So the first thing we have to look at is, when is someone signing? So in the context of your question, we're looking at several professionals in a certain context. So we're looking at a document like a power of attorney. This could be true of a trust or a will or any other legal document that needs to be notarized or witnessed. The signature needs to be notarized or witnessed. So one, it's either prepared by an attorney or it's form that someone finds online. We're going to bring in a notary to notarize or witnesses to witness if it's a will. And then the question is, who has what responsibility where, I think is what we're getting to. So as far as California, where I'm licensed, I can only speak for California, so I'll defer to my colleagues in other states on this question. But my understanding is basically this is an issue in state law across the country, is that in California, only a judge can determine legal capacity. And so what that typically comes into play, where it typically comes into play is in like a conservatorship petition. Other states might call it a guardianship. So that's when a loved one goes to court. Anybody actually can petition, but goes to court. Let's say a spouse or a child might go to court to say, my father or my mother does not have capacity right now, and we need to be in charge of their financial affairs or their personal healthcare decisions, right? And the first thing a court is going to ask is, are there any documents in place? Trust, power of attorney, healthcare, advance directive, those kinds of things. They want to defer to those. If those aren't in place, then here's where the doctor's determination can come into play. Obviously, a judge who has the only legal authority to determine incapacity is not a medical doctor, at least most are not. And so they're not serving to determine whether there actually is medical incapacity or not. What they really are is the trier of fact. So they're getting the doctor's opinion, because we always have to file, when I filed for my clients for a conservatorship petition, we have to present a doctor's determination whether, what sort of incapacity there is. And it's a form that doesn't just say they have dementia or they don't have capacity. It has many questions on it, and they have to answer all of the questions. So a judge might take it and say, well, no, this really seems on the mild side. I'm not going to find legal incapacity. They can also look at it and say, oh, these other questions are answered in a way that, yes, I think there is incapacity. In addition to that, there would be testimony from loved ones, that sort of thing. So at this point, then that would be where, the judge would basically take the power, because the power of attorney, someone who creates a power of attorney still is holding power for themselves unless they eventually become incapacitated. So if I give you, Dr. Natalie, as my agent, my attorney in fact, the power to act in my stead, if it's immediate when we sign the document, I still can act in my stead. I'm not giving you all of my power. But when we get to a conservatorship, the judge is basically saying, I would have no power to make any decisions on my own. Only the person appointed as my conservator can. So that's where we determine incapacity, right? So now let's get to the documents. Let's back up and look at if we're doing estate planning documents, let's say. So does that make sense so far, by the way?
Yes, I think we're getting like really into the details, and I'm like,
Oh,
I actually want to like step back and say, let's clear some things up. So one of the things you kind of alluded to is, first of all, let's clear, like having a diagnosis of any type of dementia does not immediately mean somebody can't appoint a power of attorney.
That's correct.
And you said that very nicely with your story of your dad, where in the beginning years, he could have appointed a power of attorney. He was, there were moments where he was good, and towards the end, probably not.
Correct.
Okay. And then you're using the word conservator. Would that also be considered a guardian?
Yes. So
Okay.
California calls it conservator, other states call it guardian.
Okay, perfect. I just want to make sure that's clear for everybody. So, and is there any reason anybody would actually get to the step of being in front of a judge and asking for a conservator or a guardian if a power of attorney was in place?
So that's a great question. And I sort of started with the end because we were talking about legal capacity, right? So that
Okay.
I was sort of going to only a judge.
Okay, go for it.
Yeah. So that's why I started there. If there is a power of attorney, okay, and this is what judges always want to, if there is one, because they don't want to take away the rights, then the question is it sufficient? So there sometimes can be a situation where we don't have a power of attorney, or a power of attorney that, as we've discussed many times, you and I, and also on Instagram and other places I've written, that powers of attorney are, just this week, I've had 2 clients call and say that their powers of attorney are not being honored at the banks, and also that a medical directive wasn't being honored at a doctor's office. So these things are happening, and powers of attorney for healthcare and finances are, written documents that are not approved at all by the court. In other words, this is just somebody signing a document notarized, here's the power. When you have a court order from a judge, that's a little more powerful. So I would say yes, where there are cases where powers of attorney are not being acknowledged and medical directors are not being acknowledged, you might have to go to court to get a conservatorship to make sure, to get an order. Again, it's a very high level, it's a very high standard for someone to take away people's rights in a conservatorship or guardianship. Recently, like for example, you had Jay Leno and his wife. Now she's obviously apparently very, very far gone into dementia. Why they wouldn't have had a state plan, who knows? But he just got conservatorship for her here in California. And sadly, he had to go to court. It's public and all of that. So that's why we want to do documents ahead of time. So ideally, powers of attorney are sufficient to avoid a conservatorship, but I wouldn't say that they're always sufficient.
Okay,
that makes sense.
So let's back up. When we're talking about powers of attorney, what are the different types of powers of attorney?
Okay, so there's 2: power of attorney for healthcare, and which can be called an advanced medical directive as well. Again, state to state, they're different languages, but every state uses the term durable power of attorney for finances. So somebody can choose the same person to be their power of attorney for finances and their power of attorney for medical decisions. If they have, say, one person that they trust for, like a spouse, typically when we have couples, they'll each appoint each other for both positions. But sometimes when you have a surviving spouse or an individual who's not married, they might have a child or a friend, be that person. Or maybe the surviving spouse says, I have 2 kids and one's great at finances and one's great at healthcare decisions, medical. Like one's bad at money and one's really good at the medical part. So I'm going to give them those duties, right? So you don't have to have the same person, but you can. Same thing for conservatorship. You can have 2 different people.
Yeah, that's perfect.
Yeah.
And then, so if we go back to this example where obviously I don't have all the details, I don't know all the ins and outs, but I just thought it was such a great jumping off point and teaching point. So this case where the son believes he cannot have his dad sign for a power of attorney because a PCP said he can't appoint a power of attorney, which if I had to decipher, I would guess that the PCP thought this man's dementia was so far gone to the point where he wouldn't know what he was doing. But even so, that's not a legal decision, but I'm guessing that's probably what the PCP thought. In a situation like this, is there a way that this gentleman, who we have no idea how his cognitive functioning really was, could he actually sign a power of attorney?
Okay, so the lawyer's favorite answer is it depends, right? So that gets us back to facts and circumstances. So let's talk about that. So in this case, the first thing I would want to say to that son is don't assume. Now, again, unless there's some state where the law says that if a doctor says you do not have capacity, you can't sign. Could be. I don't know all 50 states, right? But I've not heard of that. Could be. But in California, no. So I would recommend to that son that if he's talking to his attorney or whoever, his father's attorney, whoever might have these documents or whatever, that you then think about, like, don't assume that they can't sign just because there's a diagnosis of dementia, even where a physician doesn't say you can't sign. That doctor seems to have gone overboard a bit by going to the legal result, right? Like he's deciding the legal result, as opposed to some doctors who just say, here, you have a dementia diagnosis. And I get those questions. If my parent has a dementia diagnosis, can they still come in and sign documents, right? So now let's talk about how that works. Now we have professional standards, right? There's no law that says this is how an attorney determines capacity or how a notary determines capacity, right? So what I have to do as an attorney, what a notary has to do when he or she is witnessing a signature is get a sense of, is this person generally understanding what's going on? So let's talk about that. What do we look for? So all from a legal standpoint and as an attorney, so this is important too. So I'm going to go back to a court situation in the future if there were one. So let's say you have a document and they've signed it. And down the road, somebody says, oh, my dad did not have capacity. My sibling got them to sign that and they didn't have capacity. Well, when you go to court, and I've practiced in 2 jurisdictions, and this has been true in both, is that the presumption, so if somebody brings a case saying that my dad did not have capacity to sign a trust, my dad did not have capacity to sign a power of attorney, and let's say dad is gone at that point, could still be alive, but it's down the road a bit. The person who brings the claim has to prove that the person did not have capacity. It's not the responsibility or the legal burden that somebody showed that they did have capacity. So that's important. So it's basically what we call a rebuttable presumption. The presumption in court is that everybody who has signed has capacity. Now, if you disagree with that, you've got to prove that they don't. Okay. So that then takes us back to the circumstance. As an attorney, it's important for me to understand that my client understands not every word in the document, but basically the boundaries of their property. Do they have a home? Do they have financial accounts? They don't need to know all the banks or all the numbers or all of that, but they understand they have that. And I'm speaking generally now, so I'm just sort of giving a big overview. And that they understand, say, for example, with the power of attorney, that they're giving powers that they have to the other person, either immediately or upon their incapacity, right? So they have to have a general knowledge, but they don't have to understand every document. Even people with capacity don't understand all the legalese in trust, let's say, right? So that's what I have to do in drafting the document. Now, I'm not the notary. So now when a notary comes in, the notary has, and I have looked up to see sort of what guidance is given to notaries. And basically they need to just feel that the person, they also don't have a legal, like they're the ones that make determination or specific, standards. They're basically just acknowledging that the person who signs is the same person that's on the driver's license or whatever their form of identification is, right? But if someone is like totally, like my dad would have been the last couple of years, no way anybody would notarize that, right? But they're not swearing to full, they're not really making a full determination, a legal determination of incapacity. It's whether they're comfortable notarizing a signature of the person in front of them who's, do they seem cognizant and comprehending in the moment? And again, it doesn't matter if an hour later the person doesn't remember what they signed.
Right.
So
it's like, to me, the bar is kind of low.
Yeah. I mean, here's what's difficult. And this is what's really hard, because we as attorneys, estate planning attorneys and elder law attorneys talk about this all the time. Physicians are starting to talk about it more and more because they're giving diagnoses that they know are being relied on for people to lose control of their assets and everything. So they're getting a little more careful. There are no clear legal standards at this point for what, see, I'm not the only one. So all of our creatures, we love to be with all of our creatures. Okay. So yes, no, I think that's absolutely right. And it's really a feeling in the moment. And the other thing to remember too is that as attorneys and as notary publics, we have some sort of professional duty in general to not keep the clients that come to us from not being able to do what they want to do. if that makes sense. In other words, if I have a client that wants to put a trust together and I suddenly become very judgmental about, well, I don't think they can, so they can't, I could be doing a disservice to that client. We're not supposed to get in the way, but we are expected to have a reasonable understanding of their ability to understand what's going on in the moment when we're working with them.
Well, here's the other thing I think a lot of people aren't aware of is that a lawyer doesn't have to be involved at all.
Right. So you mean people can get documents online and that sort of, yeah, that's right. Well, that's true. And so let me go back, and that goes to one other thing. So the question is, if I am sitting with the family together, or the notary has family members that are there at the signing, or just a single family member, do we feel there's any undue influence going on? So typically, even if I often have family members call me and say, my parent has a little bit of dementia, we want to go over these things. Can we come in? Yes, we'll come in together, and please come in together because I want to work with the family. And at the same time, I need to meet individually with the client for me to have that conversation with them, so that I don't feel like they're just doing what the kids want them to do in a certain circumstance. So that would be true in any signing situation. If you've got one child there, or one, sometimes it's a caregiver. We have those horrible extremes, right? Where caregivers have, gotten the individual to leave them their estate or whatever, right? Against the kids. But if somebody's there saying sign, 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 well, that's a red flag. So in those contexts, we still look for red flags. That said, yes, you can go online. And I've said that, I've shared before with the Careblazers that you can go any state in the country, typically has, almost all of them, I think, have online websites where you can pull down the Secretary of State's, typically it's your state Secretary of State website, a financial power of attorney, and sometimes advanced medical directives too. So you can just Google Michigan statutory, that would be the word I would use, statutory power of attorney. Now, those are not going to give you the broad powers that an elder law we need. Again, California is different now because we no longer have an asset limitation, but in other states, you still need to do, it's really important if you're expecting to use Medicaid down the road to do elder law planning ahead of time with assets and everything. And typically those powers of attorney online are not going to give your loved ones the powers they need to do all that planning in the event of your incapacity, but it's certainly better than nothing. And yes, so somebody can go on and get the document and have a notary come in and get them to sign, or, go somewhere like a UPS office and get it notarized. That can also come to, which is why I was talking about undue influence. Could one child, okay, my sister has the power of attorney, but I want it to be me, so I'm going to take dad to the UPS, sign this, dad. And now there's a new power of attorney, right? So there's the notary isn't going to be paying any attention to that. They're just going to make sure the person can sign it and, knows what they're signing. Oh, and let me just say on signing, which some people don't know, you don't even have to be able to sign. You can do an X. There also in some states the ability to have witnesses come in and say, I know this person, right? So always talk to a professional, either an attorney, you can talk to a notary, to find out if you are told they can't do this, or you have, I had a situation where someone was in the hospital the other day and they said, my mom can't sign anything, but she was competent. We were going to be able to do documents. I said, we have, the notaries always have a way around that, because the law doesn't want to preclude people from making legal decisions just because, they can't get the handwriting done. So anyway, that's just an aside. So I think that, yes, you can go online, you can get a document. You don't need an attorney for that. It's not always the most robust. It's not always what's going to serve you. We as lawyers are always like cringe when people do that, probably like pop psychologists when you're a psychologist and the advice they give, right? But for some people in an expedient situation, it can at least be something to mediate before real documents are done, if that's ever possible. Yeah.
Okay, perfect. So far in terms of like misconceptions, common misunderstandings, number one, just because you have a diagnosis, any diagnosis, doesn't mean you can't sign. There's nothing about the diagnosis that would stop somebody from signing. It's really more their understanding of what they're doing, which is just in the moment. It doesn't even matter if an hour from now they have no idea. It's in that moment of signing. And number two, it's not up to a healthcare professional to give the legal decision about whether or not somebody could sign. They can always give their medical or clinical opinion, like clinical capacity, but they don't have a legal say. And then number three, technically, a lawyer may not even be involved, does not have to be involved, particularly if you get your documents online, not from one of those like national online form sites, but from like, you could, but like we're talking about, you go to the actual Secretary of State's site and you find the forms there. Technically, all you would need is the notary. There could be no lawyer involved at all.
Right, because every state typically is going to have a statutory, what's called statutory power of attorney. Again, that's finances, and then an advanced medical directive, like a form. And so again, the very basics would be to have those. And then yes, to make them legally valid, you do not need an attorney. You just need a notary or whatever's required in your state.
Which was the case for me. It was just a notary. There was no attorney involved. Any other common misconceptions you hear about a lot when people think about power of attorney. One, I would also say, is that just because you are the power of attorney does not give you the right to just take over everything right away. What do you think about that?
So I'm chuckling because I had a matter this week where somebody was like, Mr. Full Charge, like calling doctors and calling, and you have the power right away. You absolutely have the power right away. I think
Does
the
that depend on the type of power of attorney, whether it's springing or not?
So just to be clear, I sort of referenced it, but you're right to use the document, to use the language. And how is it that you say everything so much better than I do? And so, yes, so the springing means down. So I sign a power of attorney. I can say to you, Natalie, it's effective immediately. So you could go out, so, you could sell my assets that are, subject to the power of attorney. I can still do things, but you can do things, right? Or it's only upon my incapacity down the road. And again, incapacity, as I've shared before, can be defined anyway. It could be 2 doctors, 1 doctor, the spouse to decide. So there's no required definition even of incapacity as far as when the power of attorney kicks in. Now, the misconception can be, which is not really a misconception, it's just understanding that this happens. You can have a perfectly valid, legally valid power of attorney for healthcare and for finances. And again, that's really all we're talking about, healthcare and finances. There are no other different powers of attorney. You can, if you're selling your house, let's just say, and it's not in the name of a trust, so it's you and let's say you and your husband as individuals, and you go to sell it, and you happen to be traveling, for a lecture, and your husband's there. The escrow company or the title company or the attorney that's closing it for you in your state would ask you to sign, before you leave, a limited power of attorney that's limited only to that transaction. That's not what we're talking about here. We're talking about a durable power of attorney for all finances, a broad power of attorney for healthcare, again, or advanced directive, and and also HIPAA. Like you can also put on a HIPAA form. Let's say I've named 1 child for healthcare power of attorney, but I want all my children to have access to talk to the doctors. I can put all their names on a HIPAA form, as you well know, and then the doctors have the authority. But again, here's what, again, not a misconception, but here's what's happening. Doctors, I had somebody call me today. They had an advanced healthcare directive. They called the doctor. Doctor said, no, we can only talk to the power of attorney. Well, the power of attorney is the financial power of attorney. They don't even understand the difference between financial and healthcare. And so between the banks and doctors' offices and all of these places, even though you have valid documents, whether it's a statutory one or it's something an attorney has created for you, don't expect that it'll be easy to use them. Because oftentimes I have people say, why won't they? Because they just refuse. And so then we have to do other tactics and other things. I'm not sure that it's a misconception, but it's an expectation that may not be met, that just because you have a document and walk into the bank's going to take care of it. And that gets us back, or the bank's going to honor it. And that gets us back to what I was saying earlier, that as professionals, we have a duty to our client, our potential clients or our clients, to do what they're asking us to do if it's reasonable and lawful. And the banks are now starting to say, well, even though you have a valid power of attorney for our customer and our customer has signed this and we don't suspect any elder abuse, we're not going to give you access to their funds to help them in a crisis situation, which is utterly ridiculous. And some states are now implementing laws that say banks can be liable for that, but then you have to enforce those and go to court and all of that. And the banks know probably nobody's going to do that, at least right now. So hopefully these things will change in the future, but that would be something I would say just to manage expectations.
Okay. And then the other point is, let's say it's a power of attorney that doesn't go into effect until it's determined the person doesn't have capacity. That means that the person who is appointed as the power of attorney can't just start doing everything for the person. Like they can't just say, I'm the power of attorney, give me their healthcare information. I'm going to do all this. I'm going to do this. It's only after the person has been determined incapacitated if they have that type of power of attorney.
Right. And so that's why every appropriately acting doctor's office or financial institution is going to ask for the document first to review. And so many of them will kick it up. This is another thing to say in the bank. When you go into the bank, you talk to the manager, you talk to the teller, they say, oh no. I actually had somebody be told the other day in a trust account that was named in the name of the trust, and this was the new trustee of the trust because somebody had died. Financial institutions don't honor trusts. That was just the most ridiculous. Of course they do, right? And so always, don't talk to the manager, don't talk to the teller, send it up to ask them to go up to the legal department. You may still get the wrong answer coming back because a lot of legal departments are not really smart about all these estate planning things, but at least it goes up to legal. So they would look at the document. So the first question is, even if you have a loved one, let's say it's your parent as opposed to the spouse that may have participated with you, together in the estate planning. So maybe the child for the first time is looking at their mom or dad's power of attorney, right? Because they have to step in and act. They've never read it. You want to look and see, does it say it's effective immediately or is it effective upon incapacity? And if it's effective upon incapacity only, it can't be used until whatever the definition of incapacity in that document is listed as has been met. So if it says 2 doctors have to decide, you have to get letters from 2 doctors if it requires written letters, that sort of thing. So yes, no power can be used until it's effective, whether immediately or meets conditions down the road. And the gatekeeper for that would be where it's going to be used, right? So if you're faxing it into a financial institution, they're going to look to see, and if it says upon incapacity, then they're going to say, well, we need 2 letters, or sometimes even if it says 1 letter, again, the banks, they're just, squeamish is being generous. They're really kind of being ridiculous. But, if you want to look at it from their standpoint, they're not wanting to let people have control over money if maybe there was elder abuse. And there are a lot of cases, right? Undue influence that have been happening. So they're a little more skittish that way. But let's say, even if it just says 1 doctor, they might say, well, we need 2, or, they might change the standard. They're also starting to say, and this is really important too for the Careblazers, is that if you have a power of attorney that's more than 2 or 3 years old, some of them are just like, to get rid of you, will say, well, we won't accept it more than 3 years. Now, a 20-year-old power of attorney can still be legally valid if you walk into a court of law and use it, right? But the banks can say, well, our policies, we don't honor it. So
but that's crazy, assuming that we're talking about dementia that's going to get worse.
Yeah.
And so at some point, so to clarify how we said, just because somebody has the diagnosis of dementia, it doesn't mean they can't sign. However, at some point, everybody with dementia, as they progress, at some point will not be able to sign. So to have the requirement that it has to keep getting updated makes no sense.
Absolutely. It's not a dementia-based decision, right? That the banks, those who are making the policy at the bank are not sitting around thinking about the people we love to serve, right? And so, and that's going to be a problem more and more. I mean, I think eventually there are going to be more and more lawsuits that the banks are going to be called to attention and do something differently about this. But for right now, this is what we're running into.
Yeah. I will say overall, I have good things to say about my dad's bank. However, in the beginning, as I was getting ready to, I needed to have access to my dad's funds and help him with things, but I wanted to know what their requirement was because I was in the process of getting paperwork, getting financial power of attorney. I wanted to know, did you have a special power of attorney that I could use? What do you have as your requirement? It was Wells Fargo. And they're like, oh, we don't have that, but you can bring us what you have and we'll look it over and determine whether it's right or wrong. And I'm like, well, to save me time and money and all of these things, how can I make sure that the financial power of attorney I'm about to go get is going to meet your requirements? Sorry, just, bring in what you have and we'll take a look at it. So fortunately, our state's website was pretty decent because when I went to Wells Fargo and presented the financial power of attorney, they immediately said, we need our legal department to look at this. And so I just had to wait in the lobby, probably took 30 minutes. The legal department looked it over. It had everything it needed to in order for me to have access. They made me sign all kinds of things that I wasn't stealing money and things like that, but I was really impressed on the backside that, okay, they're honoring this. It's great. But on the front side, it was like, this is a gamble. Is this the form that they're going to take? Do I need to get a special clause in there? Let me know specifically. And there's just no way to know. And so we're talking about printing off forms from the state website or working with an elder law attorney and paying to make that happen and put all these special clauses in it. But then we still might not have everything because every person, every place, institution who's evaluating the power of attorney has their own criteria in their mind about what is acceptable and what's not. That just seems absurd.
Right, because it's not standardized. So the banks, state to state, the laws aren't standardized, and banks, even though they operate nationally, they can differ from each other on these issues. They're not regulated to make, at this point, they have room to make these decisions, shall we say, right? And so some banks are better than others. Wells tends to be a better bank. There are others that are really bad that I won't reference here, but some are absolutely impossible. And stories come along, our chat rooms among my peers every day about certain banks that just refuse to do all kinds of things that they really have a legal responsibility to do, and they just are refusing.
I imagine too, it's branch to branch, just based on how well their employees are trained at that branch.
Well, usually the legal department is not sitting in the branch. It's
no, they were not. Yeah.
Yeah. So that legal department would have control over most.
But I'm saying even for that employee to know right away, we need to get this to legal. It's not up to them. They can't tell me no. They can't, it was immediately we need to get this to legal and we'll let you know, please have a seat.
Right. You're right. So depending on the personnel, right, the staff in each branch, some are more, well, just like anything in life, some are smarter than others, right? And so, and some know more, maybe some have had more experience with the issue and they've had to find what the answers are. Oh, we got to kick that up to legal, right? Yeah. But the most important thing is for whoever's presenting, whoever has the power and they're presenting it to the bank, don't accept I mean, they say kick it up to legal, that's the right thing. If they want to sit there and argue with you and tell you no and make you go away. I mean, I've had people where clients are in the hospital and the bank manager says, you'll just have to bring that person in.
Yeah.
Just like, did you just hear what I said? So do not, don't give up. Make sure they send it to the legal department. You have every right to insist that they do that.
So this is so helpful. Before I switch gears real quick, anything more that you see in terms of just common confusion or misconceptions you hear a lot when it comes to power of attorney?
I think that one of the things that can be, again, it's not, maybe this, I'm thinking more of practicality than misconception. So this isn't directly addressing your question, because no, I can't think of sort of other misconceptions necessarily. But I think what is important is that when you have that power and you're helping someone with the finances, it's a job. Like, it's not easy. Like, depending on how good records your parents have kept or what they haven't kept or where the bank accounts are and that sort of thing. So any conversations, if you know that one day you would be the person, you are the person named to one day take control of the finances of mom or dad, let's say they're in the early stages of dementia, you can have these conversations with your folks and see, what does the document say? What will I need to do? What are your accounts, mom and dad? In my case, my mom was a very well organized person, but I found out later that there were some accounts that I never knew about, right? And so that's nobody's fault. It's just an issue of communication. So I think that's something that's really important to do, is to have those discussions ahead of time, just like you're going to the bank. That was smart of you to say to the bank, is there anything I need to know before I sign this? And I will say this, I just want to emphasize the point you made. I always recommend to my clients that they either, as they're doing an estate plan, or to the family, if they're participating as well, is ask, if you have a Schwab account or you have a T. Rowe Price account or you have any of these accounts or a B of A account, right? Ask those banks, like you did, do you have a form that you like? Because that form has always been approved by their legal department. And so it's okay to sign one for each individual bank, whoever has them, as well as having a very robust power of attorney that you would use for Medicaid planning, et cetera, in the future. So that's something to ask them, because it's very hard for them at that point, it would be hard for them to say, we're not going to honor the power of attorney, unless for some reason they said it's too old or whatever. So if they have them, you can sometimes go online and see if, you can Google power of attorney, Schwab or something, and see if they've got one that you can use. So that's important.
That's a good tip. Yeah, thank you. Okay, now, and if you go to an elder law attorney, there are certain things they might be thinking of to include in a power of attorney that might not be included in one of these ready-made power of attorneys from the state. Can you speak generally, like what are some of important considerations that might not always be included in a typical form, and why somebody might truly want to go work with an elder law attorney?
Sure. The biggest one is really asset planning. And again, as I've said, here in California, no longer as of January 1 do we need to worry about asset planning, but in the past we have, and all other states do. So what that means is when you go to apply for Medicaid, I'm saying Medicaid because California's Medicaid. So if you go to apply for Medicaid or whatever it's called in your state, what we're talking about is sort of the federal government, and it's a hybrid federal state program for long-term care, right? But it's not just long-term care in a skilled nursing facility. It can also be home-based services that are available to bring people into your home to care for your loved one. Just, not 24 hours, but in a supplemental way to other care. And the reason they do that is they want to keep people out of the more expensive skilled facilities if it's as long as possible, because that costs the state more. So asset planning is very important. In the powers of attorney that are statutory, as I said earlier, there are no specifics about that. So a general statement would be, when you go to an attorney to get a power of attorney, and even if they're not an elder law attorney, they likely will not have Medicaid planning language in there, but they will have more robust language even than the state's document. And the benefit of more robust languages is that it covers a lot. I mean, our jobs as attorneys are to look into the future and to see all the possible scenarios that could occur, and then plan for those in all the documents we create, and have very clear language for what happens in those circumstances, so that there is no controversy about what's supposed to happen, so that you don't have to go to court, right? I mean, somebody can always sue anybody in court, but our job is to keep our families out of court and out of conflict. And we do that by very precise language. Well, you're not going to get that in a statutory power of attorney. And so I would say that the biggest thing is really Medicaid planning that an elder law attorney can help you with. Most standard estate planning attorneys do not have that language in there. There are different ways. We have the ability, again, the statutory form is just check the box. Like, here are the powers. Do you want them all, or do you just want to have these individual ones? And it's, it's effective immediately, or it's effective in the future, and we're done. They're usually like 2-page documents, right? So when we have we create our own powers of attorney, I can ask my clients, who are all the people that who do you want? Do you want this person, that, we plan for if the first person isn't available, the second person isn't available. We can also plan for businesses. We can create whatever we want into the document. And so I would say it's just much more personalized. But the most important thing is that we can do Medicaid planning. We can allow for Medicaid planning within a document. Now, within a power of attorney. Now, I've had people say, well, really, isn't it just gifting? There's typically language in a statutory form that says, you can do gifts. Yes, but gifting can be dangerous if you're having to deal with look back periods and all of that for Medicaid planning. So just to say gifting is not enough. You have to have more specifics around how they can gift, what purposes they can gift, just something, more detailed so that it's very clear what can and can't be done. Because with these powers of attorney, also the state and other, government offices will be looking at those documents as well. So you have to have the language in there that they're going to want.
Wait, let me just ask real quick. So for Medicaid, you said Medicaid, typical power of attorneys you would find online that wouldn't cover the power to help with Medicaid. Is that?
Yeah, it might say that they're allowed to represent you with a government applying for benefits, but it's not going to say that you have the power that the agents. So let's say I'm all good now. I'm in charge of my assets. I live in a state where down the road, I may need to apply for Medicaid, and they're going to look at how are my assets, how many assets do I have, right? And these are financial limits. So let's say the limit in many states is still $2,000, which is ridiculous, but other states have higher limits. And like I said, in California, we just eliminated the asset limit. And now in all the other states, what you have to do is say, okay, let's say I have $300,000 in assets that would be countable and keep me from having Medicare. That's when you hear the term spend down, Medicaid. When you hear the term spend down, right? Every state has laws that an elder law attorney can lawfully help you with to work to organize your assets in a way that you could qualify sooner rather than later for Medicaid without losing all of your assets, right? I mean, that's really the big difference between elder law attorneys and estate planning attorneys.
And you're just saying like a typical power of attorney would not allow the appointed POA to do that.
Right. So let's say that I name you again as my power of attorney, and now I'm at the place where I'm in a state where I have too many assets to qualify for Medicaid. Sorry, I no longer can control my assets. I need somebody who can do that, right? Looking forward, with the look back period and everything, the standard power of attorney is not going to allow an agent to do that. In other words, I, as an individual, as long as I have capacity, can do that all the time. But if I have not done that, by the time it gets to the point, or it looks like in a couple of years, I'm going to need long-term care. Maybe I'm in the early stages of dementia and I might need long-term care benefits in 3 or 4 years, but I'm right now not able to control, handle my assets properly. My agent could step in and start doing planning with an elder law attorney if they have the language within the power of attorney that I've created, that they have the powers to do that.
Okay. So Medicaid language, very important. That's like one of those special clauses and information an elder law attorney could.
You know how lawyers are,
like
multiple
pages.
clauses.
Are there anything else? Is there anything else like that that's like a pretty big deal that's pretty common that is left out of standard forms?
Another situation which we encounter, and I'm really thinking in terms of the serving our dementia clientele, right? Our dementia families, is that if you're thinking of going to a facility, many facility contracts say that there's a mandatory arbitration provision that you have to sign. And most people sign these without thinking about it.
Can you explain what that is?
So basically what that means is you're not allowed to go to court. You can't so let's say there's some issue, and you've talked with elder law attorneys who are specialists in elder facility or community litigation, right, against skilled nursing or other types of community facilities. So, there can be all kinds of abuses, right? And so if there's an abuse, sometimes patients die, or sometimes that would be different because if they died, you would be using a power of attorney. But let's say there's, they don't get someone to the hospital and they become very ill, or anything that happens that typically somebody could sue for, right, would contact one of, the litigation attorneys that are specialists and sue for. If the community document that's been signed for the person who's now living, the resident, says that it's a mandatory arbitration, binding arbitration, mandatory arbitration provision is included in that document, then it means you can't go to court and you can't sue, right? You would have a judge. It's just more controlling. Like, you have a judge, there's a procedure, it's binding. We lawyers like to be able for our clients to have all their legal rights in a court of law versus an arbitration. So basically, many of these community contracts say you cannot sue us in a court of law. All you can do is file an arbitration petition, basically an arbitration claim. And often it's retired judges that come in, but that's not where most lawyers want to be in arbitration court. They want to be in a regular court of law. And then basically it says if that arbitrator decides, against you, you might have to pay all of our legal fees, right? So it's binding on both parties. Because of that, what we're now putting in our powers of attorney, some of us are, depending on the situation, is that an agent who has a power of attorney cannot sign an arbitration provision in any contract which covers the facilities. And so if in fact they signed it unknowingly, we would be able to say that they did not have the power to say they couldn't sign to bind the resident to arbitration. The facility could come back and argue about that, right? Like, well, but the important thing is that we're talking about that with clients, saying, when you look at this document, if there's an arbitration agreement, you don't have the power to sign that.
So
You
in
just
those
need-
cases, would they ask the facility to
Yeah.
take that clause out
Yeah.
before they sign?
Right. And so I sort of work with both ends, right? I work with creating the documents and then also helping the families when they are confronting those issues, right? Many elder law attorneys are just creating the documents. And so they're not really, what happens when the facility says, we're not going to take that out of the contract, right? But at least it said that the person who's giving the power away, the ultimate resident of the facility, did not give the power to be bound by arbitration. So you could at least legally potentially make the argument that it could go to court. None of these things are easy, right? I mean, there are always challenges. People can always challenge. That is something to consider to add into a power of attorney.
Okay.
But again, the most important would be the Medicaid planning.
I have a big, vague question, which I know you love.
Did you say vague?
Yes, it's
Okay.
the opposite kind of
Okay,
question
so my
that you like.
answer already is it depends.
Yeah. Do you always need a power of attorney? And let's take out going for conservatorship or guardianship. Like, do you always have to get a power of attorney?
Guess what? This is the first time I don't have to say it depends. The answer is yes. Every adult, we're even doing them for our clients who have children that are in college age. Everybody needs a power of attorney because everybody has typically some estate. Like, you would have a bank account, you have things in your name, you have cards. Everybody has something, right? Even if they think they don't. We often think kids of college don't have anything, but they might have a bank account the parents set up. Well, if there's no power of attorney, if something happens to the child and they're in the hospital or they're out of the country, everybody needs a power of attorney.
And then what would happen if they don't?
Basically, what's happening now when the lawyers, when the banks say we're not honoring the power of attorney you have, means no access. Means
So
go
you
to
basically
court.
lose assets. You have to go to court to fight to get.
Yeah, you
whatever.
don't lose, right? You don't lose, like the court, the bank still has to hold your asset, right? But it doesn't have to give it to anybody until the court issues an order. And sometimes they even won't, they won't abide by the court's order. Then you've got to go get enforcement and that sort of thing. But here's the thing. When you think of what we're talking about, all these legal documents with terms on, what we're really coming down to is each of us as living human beings have our person, right? And we have our estate, whatever that is, right? Whether it's a piece of furniture, whether it's a bank account with only $100, we all could be $1 million, right? We all have that. And so in the event that we're incapacitated in any way, because remember, powers of attorney, both for healthcare and finances, are only valid during one's life. When one passes away, they're no longer valid. So they only last as long as the person is alive who's given the power. But as we're alive, if we're incapacitated and I have a bank account sitting there with just $3,000 and I need to get that money out to pay my rent for 2 months while I'm in the hospital or something, no one can do anything. The bank will not honor it if I don't have a power of attorney. So, my best friend can't come in, even my spouse can't come in unless they're on the account. See, so that's what's important. So that's why even at a minimum, have something statutory, have somebody named. And it's hard. Like we think, well, that'll never happen. I'm young, I won't have those issues. But we all see when people get injured, right?
Mhm.
Or die early, young.
Yeah.
So yeah. So the answer to that was easy. That was
Okay. Well, I think I was thinking of something different. I was very shocked, but yes, no, I hear what you're saying. And it's also a perfect place to say, here we are talking about power of attorney with the focus of the person with dementia appointing a power of attorney. However, this is a great reminder that anybody watching this video right now, it's time, if you haven't already, to make sure you have power of attorney paperwork filled out for themselves. I'll leave with this and maybe I won't get too much into it, but for my mom, I was not her power of attorney, but I was the one who was in the hospital. I was the one talking to the doctors. I was the one who made the decision to take my mom off life support. That hospital has no record of me being a power of attorney. I wasn't, no signed paperwork. And I think like definitely for financial, it seems very clear and stringent, of the process, but it seems like with medical, it really is about which doctors are there, how the hospital is operating, maybe how urgent the situation is. But I never once had anybody refuse me anything about information or needs for my mom. And I didn't have power of attorney. And I realize I'm very lucky and fortunate because it could have been very tricky because my dad wouldn't have been able to do anything.
Was your dad there with you
No,
at all? No.
no,
Yeah.
at
And
all.
right. So that gets to like, we can create these legal documents, but we're not in charge of how they're actually used in the real world. And the real world is real,
Yeah.
crises,
Yeah.
different professionals, different hospitals, different medical rules, right?
Yeah.
So you could have someone, and I think you would know much better than I, in a hospital situation, they're looking to family members. So if there isn't a family member who's showing, if you're the only one that shows up, then
Mhm.
maybe that's whom they ask. I had a
Yeah.
situation this week where somebody was in the hospital and we brought over all the documents. So they had them and they put them into the computer, and they had them. So
Yeah.
the people who, but that was not a person who had family. Those were named friends, right?
Right.
So I think in the case where it is a family member and there's a more crisis situation, like in your case, right?
Mhm.
Like they don't want to make the decision. They don't want to decide to take your mother off life support. Now it's interesting. Did they ask for your dad's opinion at all?
No, that's the thing. I think, oh my gosh, like my dad just trusted me to do everything, but like I just think this could have been a really nightmare situation if our family was not all on the same page and everybody didn't just trust me.
Right. And what a burden for you, even though you have siblings, right?
Mhm.
To have to make that decision, even though your siblings might have said, okay, but you, like you just said, you were the one that made the decision that it had to happen and that they were supportive of it.
Mhm.
And that's the other thing when you work with an attorney, right, who can help you put the documents together. But that's not the limit of what we do. We really talk about planning and family and bringing families in to talk about these things so that the kids know this is what mom wants, this is what dad wants, and
Yeah.
that it's not just, okay, don't do life support. Well,
Yeah.
I mean, how that there are different stages even of that, right? Like,
Well, and
so
that's a whole other box of worms because, my mother didn't want any of that stuff. But by the time the ambulance came and took her, they started doing all of the things. And by that point, she's already intubated. She's already, and when they look at the paperwork after the fact, they're like, well, I see your mom didn't want these things, but here we are. And so it's like, even when you have some of the stuff filled out, it's like just the way it is. And the crisis situation, sometimes like that ambulance is just doing whatever they need to do to keep the person alive a lot of times, even though that may have been against their wishes. It's like not a perfect thing, but the best thing you can do is do as much as you can to hopefully make things go as smooth as possible and have your loved ones' wishes followed and be able to have the authority to make those decisions. But I just think so much, especially in my mom's case, about like, how did we even get through this? No paperwork, no nothing. They didn't follow her wishes, all that. And it happened. So that's the whole point when I was like, do you always need a power of attorney? I mean, technically the answer is yes. But in my case, it was like, but I didn't have one and somehow it worked out. But I think that's probably, I would hope, a minority situation. Like it's not as common. I don't know. That was my personal experience.
well, I think in that circumstance too, the hospital would much rather be able to say, daughter Natalie made the decision, not Dr. So-and-so. Like the hospital did not decide. Like they want to pass the buck to you,
Yeah.
right? In the decision making. And so
Yeah.
they're not as concerned, just like the ambulance isn't, with determining at that stage, right, what your mother's wishes were necessarily. They
Mhm.
just don't want to make the decision in the absence of any documents.
Mhm.
So I
Yeah.
think that, that could be part of what that
Yeah.
was. But if you have a case, like you said, your siblings, you were all in agreement. There are circumstances where you could have a spouse and a child member, the Terry Schiavo case in Florida. You could have situations where you have siblings that disagree about parents. You could have a spouse and a child that's fighting. Usually the spouse will be given more consideration. But if multiple people are at the hospital at this time and they're disagreeing with each other, now you've got problems, right?
Yeah.
And that's where the documents come in, where
Yeah.
you really need them. So yeah, it's just safe. It's like an insurance, it's not really like an insurance policy because you always know the insurance is going to pay out, but it's knowing that you've at least put everything in place so that if there is an issue, you've got a foundation on which people are making decisions and honoring your wishes. You've made your wishes clear, because in a case where you have multiple people arguing, if one person has the power, that's whom I'm guessing the hospital is going to rely on, right? To say, they have to, this is the person who who makes the decision.
This is so helpful. Thank you. Hopefully this cleared things up for some Careblazers. I just feel like a lot of misunderstanding is because a lot of the healthcare field, a lot of the people who are supposed to be on the receiving end of knowing, like either reviewing the documents or understanding the process, they don't always know. And so it's just important to know some of these basics so they know where their rights are, that they can demand, elevate this to legal. So I appreciate you coming on at the very last minute to share your thoughts and your information. Explain to us now, attorneys can really only practice in the state that they live in, correct?
Right. So,
Or the state that they're licensed in. Is that
right,
more
so we have
correct?
to be licensed, right? We have to be licensed. So in my case, I'm licensed in California, took the California bar, and some states allow what's called reciprocity. So I don't know how this works with psychologists, but there are some states that they'll honor another state's. You still have to be admitted, but you don't have to take an exam necessarily. Most states require their own bar. Somebody passed the bar exam in order to be licensed, but people can be licensed in multiple states. But yes, so in order to give, to practice in that state, or technically to give counsel on that state's laws, one needs to be licensed in that state. And let's just say this, the reason for that is that while we talk about, we've seen a lot of Supreme Court discussion lately, there is federal law that covers all 50 states. But in the beauty of our constitutional republic, we also have state laws. And so where the federal law doesn't step in and take power over state laws, the states are allowed to decide. And so every state makes its own law in its legislature or through the court's case law, right? So law is really a creature of federal law and state law. So in order to practice in its, to practice with state law, you have to know that state's laws and be licensed in that state. That's why.
Okay. And I'm asking because I want to make sure anybody watching who is in California and is looking for an elder law attorney, they know that they could reach out to you.
That's very sweet of you. Thank you. I would be delighted to speak with the Careblazers who are in California.
What's the best way for them to reach you?
So I think on Instagram, it's just at Jane Allison Austin. If you'd like to email me, you can email me at austinlegacyplanning@gmail.com. So Austin with an I, legacyplanning@gmail.com. So Careblazers, if you're in another state and you're interested in seeing if I can let me know. I've got colleagues all across the country that I'm in touch with every day. I can refer you to some attorneys in your state. So please just, even if you're in California, I would be delighted to talk with you to potentially serve you or your family. And if you're in another state and just need some extra guidance about what to do in your state, please feel free to reach out to me, either on Instagram or email would be great.
That is very generous. Thank you. Appreciate that.
You
All
bet.
right. All right.
Thank you.
Well, that's what we have, Careblazer. Thank you so much for joining us today. Thank you so much for your time, Jane Allison.
My pleasure. Thank you, Dr. Natalie. Bye, Careblazers.
Also, Nico gets a belly rub for every person who subscribes from this video. So if you haven't already, click the red subscribe button. It's totally free, and Nico says thank you very much.